Present. All right, Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. Next point is public comments. The special meeting comment period is limited to section 12 on the agenda. Each person is limited to a maximum of 3 minutes of speaking time. Anybody with a public comment?
Well, unfortunately, I have to record this because Mr. Rademacher edited the last meeting. So, we open every meeting under the banner of liberty and justice for all. However, I ask you, do you even know what justice is anymore? You want to hire Rademacher for harbor master, so I ask you, is it justice that Rademacher continues to reside in a red tag building that every one of you are aware of? No, that's not justice. It is complete disregard for law. Is it justice Rademacher deletes April 23rd recording where Dan Schmidt implies an ongoing investigation? No, that's not justice. That's violation of law. Is it justice that Rademacher lies to the county officials regarding this matter in the red tag building? No, that's not justice, but you have permitted this behavior under the color of authority. Is it justice that Rademacher falsified a complaint against Annie Niemer for sexual harassment? No. That is not justice. That is retaliation and your allowance of it in violation of law. Is it justice Rademacher utilizes harbor time to commit to another full-time job utilizing harbor resources? No, that is embezzlement. Is it justice Rademacher utilizes, or lastly, is it justice that Rademacher provided expired public official bonds that you're required to have with your oath of office? No, that is not. You are in violation of law. What do you all do instead? Commissioner Evans preaches his 30-second sermon by sprinkling prayer over corruption, which he thinks makes it righteous. We are 6 months into a new administration, and nothing has given this community any signs for hope of a new harbor. Rademacher does not have the ability to develop partnerships because he's a known liar. No one wants to work with this harbor with a person that has no credibility. You should be very concerned because you have thoroughly violated the oaths you took. You don't have public bond insurance, so you are all liable in your individual capacity. There are other individuals who qualify for harbor master. Is it worth losing the harbor over keeping this individual? And let me tell you one more thing. Everything I write, I have documentation to prove everything I say and or declarations from witnesses. So, Mr. Rademacher, you think this is funny? We'll see how you're laughing at the end of the year. Thank you.
Is there anybody else who'd like to comment?
So, is this a special meeting or a regular meeting?
It's special.
Okay. You familiar with 11-125, the government code, on why and when you can have a special meeting and how you have to do it? Okay, well, 1125.4 will tell you that if you don't do it correctly, the meeting has to stop and everything that you do during the meeting has to be redone. You're going into a closed session. Mr. Rademacher already said there's not a packet, so we don't know what you're talking about.
Mm-hmm.
But just to let you know, because that's getting to be an issue. And also in the harbor navigation codes, you guys have been running multiple meetings throughout the weeks and the months. And according to the harbor code, you can only do for a month. So just so you know that. So I guess we'll sit back and watch and see what you do and how you handle it and go from there. Thanks for your time.
Thank you. All right, is there any other public comment? All All right, at this point,
I'm sorry, Chair, I have a comment before we go into closed session.
please go ahead.
Before the board enters closed session, I respectfully request that item A and item B be pulled from today's agenda. Item A, public employment, has now been discussed across several special session meetings. At the last meeting, we were supposed to compile written evaluations, but we did not. Instead, we did an oral evaluation. And you asked that the harbor master himself was instructed to record and compile these reviews in his own performance document for his personnel file. This is a clear conflict of interest. No employee should be documenting their own evaluation. That responsibility should have fallen to the chair or the district secretary. This undermines the transparency and integrity of the process. Unless the board is verifying a properly documented evaluation prepared by appropriate district officials or legal counsel, I believe that item A should not be moved forward unless this is to discuss posting the harbor master job ad. Regarding item B, the proposed employment agreement now under consideration was not drafted by our district attorney. It was created by the harbor master himself. This is wholly inappropriate. The agreement does not reflect negotiation or legal oversight and does not serve the best interests of the district. I request that the district attorney be tasked with drafting an official employment agreement that aligns with public agency standards and represents the district's interests. Until such a document exists, item B should also be removed from the agenda.
Okay, just to clarify a couple things. So the contract was drafted by PBK originally, and I proposed some amendments, which is typical during negotiation. What were your other concerns about that? The performance evaluation, the board directed that the transcript be prepared. We could have Gavin do that. That's fine. It's just going to be like a Zoom transcript or AI transcript.
My issue with the transcript is that the last recording you did, rather than doing it through Zoom where it can't be altered, you recorded it on your phone. It's cut. A member of the public reported it. I reviewed it. It's cut. You recorded that, and so I don't know that it's clear or unclear on what has been left out or not left out. And regarding you did your contract, not an attorney. It's been heavily edited, not slightly edited. Again, I'm requesting that the attorney prepare the document and bring it back to the board so we have time to review the document.
So in the weeks between the last meeting, it's been distributed to Kyler, our attorney, and Ruben. They've both gone through it. They didn't have any objections to it, so they're waiting to get direction from the board from today's meeting if there's any additional changes. So it's been reviewed by BBK.
I'm sorry to not accept your statement. There's been several statements where they've been false and against what county has said, what the commission has said, edited documents, and I do not accept your statement.
You can talk to
If they
Kyler.
email me or speak up to this, then
Kyler will be on the call.
verified.
So.
Any other commissioners would like to have a say on this?
Yes, I've gotten an awful lot of pushback from the public, I should say, about the contract, harbor master contract, and the expeditious manner in which it was voted on. My recollection is that we all participated in an evaluation matter. I was the first one to speak, gave a brief overview, then I think, and I gave a satisfactory eval. John then took over and upped the ante to, I'll call it satisfactory plus. And I think Rick came in and kind of gave it a little bit higher evaluation than that. And submitted a written eval, but I never saw what she wrote. Don't have access to what she wrote. And Gerhardt, I think you made reference to an eval that included 5 areas where he's done well and 5 areas that need improvement. I never saw yours either. And so I presume that none of us have, other than the people who spoke orally, John and myself, nobody has had the opportunity to consider what the other commissioners have said in their evaluation of the harbor master. And so what happened moments thereafter, there was a motion to accept the offer submitted by the harbor master, and a quick second and a vote happened bang, 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 without really any substantive deliberation as to what was contained in some of the evaluations or in the proposed contract that was presented to us for a vote. And so I actually, I'm not sure I agree with Ann, but I join in Ann's concern about the contract and what I believe to be our responsibility as commissioners to review it adequately and to discuss it, deliberate it amongst us before we act on it. So those are my comments.
Mm-hmm.
So you don't have to act on it today if you don't want to, but the contract has been out, at this point for, like 6 weeks. The only thing that's really been changed is the cost of living increase and the performance-based pay. So the original version had a 5% automatic increase, and as a concession, some commissioners objected to that, so that's been removed. So there's not an automatic 5% increase. So I think if anything, it's really more of a concession compared to the original contract that was presented. I mean, it's been out there for a long amount of time at this point. And it's also really follows the previous harbor master's contracts. It almost, there's just like maybe 3 or 4 sections that have changed. And so I think it's been out there for a long time. We were originally discussing my performance, like 6 or 7 weeks ago. We've had, 4 meetings discussing my performance. So,
Can I call for a point of order? Under the rules, this is a board discussion and it's not for an argument from an employee or from the public. It's a board matter and a board discussion. It was open to the board for discussion. And again, 11:25, you're gonna have to vote before you go to this closed session if you wanna follow proper special meeting rules. Just letting you know.
Here's my official letter requesting that an employment attorney review the employment contract.
So Michael Travis is an attorney who specializes in employment law with BBK, and he is
Point of order.
the contract.
The board meeting, not.
I did want to respond to time.
I don't know what you're talking about, Hank.
I know, that's the problem.
I'm sorry, Chair, this is my request to you to remove items A and B from this special meeting.
Somebody else. Rick, what do you think?
I don't see removing them, but if Ann wants them removed, I guess you remove them and do it some other time, and then this guy said we're out of whatever, I don't know, it's getting too,
So whatever
it's getting too weird for me around
Why don't
here.
we consult our attorney and get Tyler in
This
Yes,
whole thing, I don't think, I'll say one thing, whatever the other one's performance evaluations wouldn't change my mind of Mike. I'm a Mike guy, so what can you say? He's doing a great job, better than anybody I've seen. So, we already went through this performance, so it wouldn't have changed my mind at all. This wouldn't change my mind. So if you want to keep going on and on and on and bringing it up and whatever you want to do, it's fine with me. I'm not going to change my mind any. So.
I would like an accurate contract presented to the board from an attorney and give us time to review it.
This was prepared by.
I'm sorry,
Yeah.
point of order.
And so that's up to you, Gerhard, I guess you.
All right,
Yeah, we
Call.
do you want, why don't we talk to Kyler in closed
Yeah.
session?
go.
Yeah, in closed session.
All right.
So we're going to close session when I put this on the table, items A and B.
You have
Is
to
it a
vote.
mystery whether we're
I
gonna discuss them or
can-
not?
You can skip
I can
over
drop
them
it in
closed
during
session.
closed session,
Yeah.
and I'm totally willing to entertain that up here.
Yeah,
I just wanted to make sure that I have.
Yeah, if you want to skip over it in closed session, there's no, you're not like mandated to address those issues if you don't want to.
I'm requesting a motion to drop public employment from, item A, public employment, and item B, conference with labor negotiations, for the reasons already stated.
Okay, Do you have a second? Do we have a second on that one point? A second. Okay. Let's vote on it then, I guess.
Commissioner Schmidt,
Yes.
Commissioner Shepard,
Yes.
Commissioner, or Vice Chair Niemer,
Yes.
and Chair Weber.
All right, can we go along? Yes. Okay, so, items A and B are removed from the schedule. I hereby adjourn to the closed session.
Read out what we're gonna, do during the closed session in public.
Very good.
And
Very
You
good.
gotta read out what we're gonna do.
There you go, Rick.
Point of order on a special meeting, you have to tell the public why you're having a closed session. You have to tell the public in a special meeting, if it's, because you call it a special meeting, that it's a risk or danger to the public or the harbor, and it's necessary to do it without delay. And if you can't substantiate that, you have to cancel the meeting. That's what it says in the government code. Just letting you know, you guys can do what you want.
Yeah, that's not what Tyler's told us, but we can get him on the phone in a second.
Yeah, come on, get him on.
Yeah, do you want?
Yeah, but I know, one thing for sure, Gerhard, is you gotta read C, D, E, and F to let people know what we're going into closed session for. We've always done that. That's all I know.
Okay, yeah, all right.
Everything else is
Yeah, I was about to.
convoluted to me,
That's
but
weird.
anyways, I know you have to do that. and-
Yes,
Yeah, okay.
that's what I'm gonna do. Let me.
But you can't go into closed session until you read those
Okay,
in open session.
yeah.
We're in open session right now, we have a question from the public. Are you able to address that? Let me put you on speakerphone if you're okay with that. Okay. So the members of the public is, bringing some things, to the attention that we're not permitted to go into closed session unless there's an emergency, or you wanna restate your point, Hank?
No, I stated it. You should understand the government code and you should know what you're talking about.
Okay, so
11.125 and 11.125.4. You
I
can't
have
have,
to, yeah, the general contention is that the special meeting has to be called for, urgent items. Are you able to speak to that, Tyler?
I'm not quite sure of the question. It's not clear to me what the question is. Can you rephrase it for me, Mike?
I think generally that there's a concern that a special meeting cannot be called unless it's an urgent matter, which is not my understanding, but,
No, that's not accurate.
okay, thank you.
11.25.4 of the government code.
No, the district can call special meeting. It can't approve certain things at special meetings, but the district can call special meeting if they satisfy the notice requirements set forth in the government code.
Did he hear that government code?
Government code 11.25.4. 11.125.4.
You have to study that one.
To be, wow. Anyway, and following.
Yeah, that's not my understanding, and that's not it's not an accurate portrayal of the requirements set forth in the government code to call forth a special meeting.
He's not reading it either.
Okay, well, we can take it up at the bar and we can discuss it. It's a government code that's held up at my meetings.
I have it here, if it matters. 11.125.4 in the government code. Sub A, a special meeting may be called at any time by the presiding officer or by a majority of the members. A special meeting may only be called for one of the following purposes when compliance with the 10-day notice provisions of 11.125 would impose a substantial hardship on the agency. And these are the subjects to consider: pending litigation, proposed legislation, issuance of a legal opinion, consider disciplinary action of an employee, purchase, sale, exchange, lease of real property, license examination or applications, take action on a loan or grant, consider a response to a confidential draft audit report, provide for an interim executive officer upon the death, incapacity, or vacancy in the office of the executive officer. 8, the body shall provide notice to each member of the body and to all parties that requested such notice, published in a newspaper of general circulation 48 hours before the time of the special meeting, made available to newspapers and the radios and TV stations, blah, 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 just goes on and on and on.
Read, subparagraph C.
C. At the commencement of every special meeting, the state body must make a finding in open session that the delay necessitated by providing the 10-day notice would cause a substantial hardship to the body, or that immediate action is required to protect the public interest. Okay.
And then the last sentence is failure to adopt the finding terminates the meeting.
The finding shall be made available on the internet. Failure to adopt the finding terminates the meeting. Anything else, Hank?
Thank you.
Okay, so
Sorry, Mike, is there another question?
I don't think so, yeah.
Okay,
Thank you,
all right,
Tyler.
thanks so much.
Okay.
Yep.
So I don't think that's relevant to what we're doing today.
I kind of remember all that too, that, you know, I read that code actually many years ago when I was the president, or a few years ago, and when you call a special meeting, those are the prerequisites that you need. And I believe that we have achieved those prerequisites with what we're meeting on today.
All right, then let me read what we're going to handle in closed session. There's a point C, public employment, Government Code Section 54-957, titled General Counsel. D, conference with legal counsel, existing litigation, Government Code Section 54-956.9D1. Name of case, Sutter versus CCHD, case number CV25-1022. E, conference with legal counsel, anticipated litigation, Government Code Section 54-956.9D2, one potential case. F, conference with legal counsel, anticipated litigation, Government Code Section 54-956.9D4, one potential case.
So, if I may, and I am interrupting, and I apologize, you can stop me. What is the emergent nature that it can't be held at a regular meeting, and it has to be done now? And you have to, by that code, you have to take a vote on it that yes, you all agree that it's an emergency need for today's meeting before you go to closed session.
So you just heard from our legal counsel that that's not accurate. This code that was being read is not applicable to this situation.
Okay, again, this is for the board. You just had two board members that read it, and one of them agreed that that's true. You guys do what you want. Have a nice day. Enjoy it.
All right. We'll adjourn to closed session.